Alex here with a high conflict child custody video on delay tactics. I'm surprised I haven't done a video on this yet. I do get this a lot. People ask, or don't even ask, they just kind of comment in frustration that their ex is just delaying, that everything is a delay tactic. And I think specifically one of the questions that I got recently was, how long is waiting, or how long is too long to wait after sending a letter to your opponent? And they said specifically that their opponent was never going to respond to the letter because they never do, and that they only end up using the time to just delay and drag things out. I do actually have something to say about this. In my 8 years of representing myself against my ex's attorney, I experience this all the time, and here's what I learned. Get a deadline set, whether it's a deadline to respond to your motion or a court date. And once that deadline is set, try not to budge. If you do have to budge, it's okay to budge a little bit, but the point is, don't withdraw your motion. Don't vacate your hearing. Hearings, I'm a lot stiffer on. If a hearing is set, try not to let that thing get moved, especially if you're real close to it. If the hearing is like 2 months away, it's not as bad for it to get moved. The main concern that I have with hearings is that you may have witnesses lined up to appear, and changing the court date could frustrate that process. Motions and deadlines to file like oppositions to a motion, stuff like that, I don't mind giving a little bit of an extension on that as much. Because here's the thing, there is a due date, and if you move the due date back a little bit, it shows that you're not just trying to be a jerk, it shows that you're willing to sort of flex, but the fact of the matter is there will still be a due date in place. And if they try to move it a second or third time, of course I would refuse. In my case, my ex's attorney routinely would ask to move a date back on, or not move a date back, to have a little bit of an extension on filing an opposition to my motion. But she wouldn't usually ask more than once. I think there may be one time that she asked twice. And I love this process because when I would send letters or when I would send emails, I'd be waiting for months. And sometimes they just wouldn't answer me at all. Other times they'd string me along. They would answer and then I'd reply, and they'd answer and then they'd reply, and then after several months of this, I just got sick of it. What I realized was, if I file a motion, yeah, they may ask for an extension, but they're only going to ask one time, and it's not going to be a very large one. So at least I can get a date etched in stone to resolve this issue. So I don't know if that made sense to everyone as to where I was going with it, but where I was going with it is this. You need to get some kind of deadline to light a fire under their ass, because that actually does work. And not only does it work, but I actually ended up getting my ex to settle a bunch of times. There were some really small annoying issues that really would have looked bad for us to go to court on, but she would not agree until that due date started to roll around. There were a couple of times that she didn't even want to file an opposition to my motion. The due date to file the opposition was enough to get her to stipulate. One time it was a child support stipulation. I can't remember what the other ones were. And there was at least one time, maybe 2 times, when a court date, like a date for a hearing, was coming up, and it would usually go right up to the last couple days, but right up before, the date of the hearing, the day before, maybe the day before that, I'd get an email, and all of a sudden, next thing I know, there's a stipulation ready to go. So not only are you going to actually get the matter resolved by a specific date, plus or minus maybe a couple of weeks, well, plus a couple of weeks, not minus, or you'll get a stipulation. So, sorry, I think that's what I said. You'll either get a stipulation or you'll get it resolved through the actual process of the litigation. I actually did use this example on a friend of mine who won an appeal. And he won his appeal, but no hearing date was set for the court to address the results of that appeal on remand. That's what it's called. When the Supreme Court remands a decision back to the trial court, they're supposed to set, well, they don't always have to set a hearing. Sometimes they can resolve it with just a written order. But in this case, the judge didn't resolve it by written order, nor did the judge set a hearing. So my friend was trying to get his ex to agree. He sent email after email after email. They talked. They went back and forth for months and months. And then a year went by. They went and had discussions at like a restaurant. They had sit-downs. They had phone conferences. And she strung him along for about 1.5 years. And he was just so frustrated. And what I told him was, I kept telling him, if you don't set a hearing date or somehow trigger some kind of deadline, you are never going to get the relief. He set the hearing date, and lo and behold, or he filed a motion that triggered a hearing date, and like a day or two before, it might have even been the day before, she stipulated, she agreed, and he won. He got the settlement that he wanted. He wanted joint custody, and he got it not even by going to court. He got it by stipulation. Now, there are a couple of things I wanted to mention. She asked to push that hearing back several months. She asked to vacate it and go back to just talking about it. She even tried to exploit the fact that it took him a year and a half to set the hearing. She tried to say that because he waited so long, he was no longer entitled to the relief that the Supreme Court's order reversing was going to entitle him to. So she even used, and I could talk about this in my video, exploiting good faith. Here the guy is taking a year and a half because he's actually trying to consult with her and talk to her. And she exploits his good faith and weaponizes it, uses it against him, tries to say that because he waited so long, he shouldn't even get the relief. Anyway, I told him, do not extend, leave that date where it's at, because if you do, you're either going to get your hearing or they're going to cave at the last minute. There is something about these types of people that delay and delay and delay and drag things out and are just wasting your time. There's something about them that when you have a due date set or a hearing set, it lights a fire under their ass, and they will get back to you when you have a date etched in stone. There's something about their back getting pushed into a corner that actually makes them take some kind of step either towards settlement, or unfortunately sometimes you just have to litigate it out, which I did have to do a bunch of times, but not every time. I hope this video inspires people to do the exact same thing, which is to send a whole lot less letters and talk a whole lot less. And you know what? There's nothing wrong with trying to work things out while a motion is pending. There's nothing wrong with trying to settle while a hearing date has already been set. I think that that is one of the greatest ways to actually get both sides to really try hard. When there's no date set, when nothing is due, it's too easy for people to just be like, I don't know, and then they can just hum and haw, and that's if they're actually thinking about working with you. With personality disordered abusers, they strategize. They're like, I'm not going to do anything. I like the situation the way it is now. I'm going to make him think that I want to settle, and I'm going to drag this sucker on for a year or two. And there are people who do that. So anyway, there's nothing wrong with having a date set for a hearing or some kind of paper pleading deadline and trying to work things out while that date approaches. There's nothing wrong with that at all. It's a great way. It's a way that I did it. It actually got things done. It actually accomplished things. And you know what? It doesn't feel as anxiety-inducing when you know that that date is coming. When your opponent just dragging their feet and dragging things out, it can be very anxiety-inducing. To think that you don't know if they're even going to ever come to a solution or some kind of settlement offer, you could lose sleep. And you know you're going to lose sleep also if a hearing is coming up. But at least you know you're going to get some kind of resolution. Maybe you won't win, or maybe you'll lose, but at least you'll get some kind of resolution. And if you do lose, you have other things that you can do, like filing an appeal and such. You can't do anything about not getting a decision, not getting an order, not getting some kind of ruling. There's nothing you can do about that. You're completely and utterly powerless when that happens. So anyway, I don't need this video to drag on any longer. If anyone here wants to post anything in the comments below about an ex or an opponent who just dragged their feet and used delay tactics and stretched something out for an incredible amount of time, go ahead and post in the comments below, because people need to see that this is a thing. And if anyone here has tried what I've mentioned, if anyone here has tried like the whole process of filing a motion and having a due date set on them to file a response, or having a hearing set, and having a much better sort of seeing much more of an effort out of their opponent to actually resolve it, if anyone's noticed that, go ahead and post that too, because I want people to see that this does work. It worked for me. It worked for my friend. I think it works. So anyway, go ahead and post that if anyone has any kind of personal experience with this, and I guess I'm going to go ahead and see you guys next time.